Cool. That's Michelle. So anyway, we it's always best to
Hello, Michelle.
Well, it looks like it's 1 o'clock and I think we've got about 9 people on. Shall we get started? I wish everybody would put their video screens on so I can see you. Otherwise, I feel like I'm talking to myself. Oh, Karen, look at you with the
I'm in
beach
Hawaii.
behind you. Look at that. I can't hear you. Turn on your mute.
Okay.
You're muted. Can anybody hear Karen?
It's wishful thinking on my part. You still can't hear me? I am not muted.
Michelle, I'll get on video in a second. I'm just in the car.
I still can't hear her. Maybe that's me. Somebody else try and talk. See if I can hear you.
I can hear you and Karen loud and clear.
Got it. Okay, that was me.
Okay.
I can hear you too, Karen. That was totally me. All right, I'm going to get started because it's 1 o'clock. So for anybody who doesn't know me, I'm Michelle Smith. I'm the attorney that kind of reviews all your files, and I'm here for any questions. And we are going to talk today about the forms update. So MAR came out, as they always do every year, August 1st with any forms updates. This year, very easy, really not that many substantive changes. And so I'm gonna have to, sorry, I'm home with my children. I see them walking by. So this is not gonna take very long. Every form was changed, just so you know, but very slightly. So there's only a few substantive changes, and I'm going to attempt to share my screen so we can actually look at the changes, which for anybody who knows me, technology is not my forte, so we're gonna do our best, but I think I got it figured out. So I'm gonna share my screen with you, and we're gonna go through some of the substantive changes that happened, and then I will be available for questions, because I got to tell you, it doesn't take that long to go through this. I've done it at a few other market centers, and I'm kind of done within 15 minutes. So I will be available for questions as well, but let's go through them. So, and please speak up. Just take out your microphone or unmute yourself and speak up if you have questions, because I'm kind of only looking right now at my shared screen. So I can't see all of you, but please speak up if you have questions on anything. So we are going to start with the, let's see, we're just going to start with the addendum or amendment to purchase agreement. It's on every form. This same change was made, but this happens to be the first form that MAR put in there. And you'll notice on line 4, where it says date of this purchase agreement. What MAR attempted to do was to clarify anytime somebody is referencing the date of the purchase agreement, instead of guessing if it's a final acceptance date that they're talking about or what they're talking about, they clarified it to say what they're talking about is the date of the purchase agreement, which means line 1. So this line 1, where it's the date you put in there, is going to be what is referenced throughout the purchase agreement, unless it specifically says final acceptance date, which it does in a few spots. But otherwise, whenever a document is talking about date of the purchase agreement, they're talking about line 1, the date that you put there when you're writing it up. So that change happened on almost every single form. And that's why it looked like there were a lot of changes this year, but there weren't. It was just that every single form, they put this date of the purchase agreement on there. Let me know if you have any questions on that. Otherwise, we are going to go to the next one, which, see, I didn't learn how to scroll through these better, but anyway, we're going to go through here, the addendum to purchase agreement, the CIC addendum. This has a couple of things I want to draw your attention to, besides date of the purchase agreement, which had that change on that document as well. If you go down to line 70 through 74, you will see the substantive change that was made on this document. What they did is, because the statute changed, they were allowed to change this document. And all that was changed was in under subdivision 3, now when a person is giving notice, that a buyer is giving notice to a seller of their desire to cancel the purchase agreement based on this 10-day right of rescission. So if they reviewed the documents and decided they want to cancel, you have to do that written, of course. This is real estate. It has to be in writing. You used to have to deliver that written notice by mail or hand delivered. Now they have added, finally, that it can be delivered electronically. So that's the only change, is that they updated the statute to allow email, electronic delivery, and so they were able to update this document. So that's really the only change on that document, nothing really substantive beyond that. Any questions on that, or we are going to skip on through to the counteroffer addendum. Okay, that was on the CIC. And now we're going to go to the counteroffer, which has a couple of things that I thought were really good. I was glad they made these changes. Sometimes I'm a little nervous about what they end up doing, but these have been pretty good. So here's the counteroffer addendum. Again, you'll see line 4 where they did date of the purchase agreement has changed. The next thing you're going to notice is that they did clarify that this counteroffer addendum on line 7 is valid only upon signature and delivery of the purchase agreement. So there was always a question on, do you actually have to sign the purchase agreement if you have a counteroffer? And they're clarifying, yes, you need, the purchase agreement itself needs to also be signed and delivered in order for this counteroffer addendum to also be valid. Because remember, the counteroffer is stating specifically that it encompasses the entire purchase agreement and with these changes. So you need the purchase agreement because that is encompassed into this counteroffer. So they just clarified that you need that purchase agreement signed and delivered in order for this counteroffer to be acceptable or considered executed. And then the other thing I really liked is, this is a big change, line 29 and 30. They have now added the final acceptance date to the counteroffer. So you don't have to go back to the purchase agreement and put the final acceptance date on the purchase agreement. Because I don't know how many times I've had to tell agents, poor agents, to go back and tell them, you're missing your final acceptance date. And I get it. It's because they were going back and forth with counteroffers, and then they finally had an agreement. And who remembers to actually go back to the purchase agreement? Well, now you don't have to, because there's a spot for it right on the counteroffer. So no longer will I bug you, where's your final acceptance date on the PA? Because you don't need it there. So I will look up and see that the little box on the purchase agreement is checked, that there's a counteroffer, and then I will know that I don't have to bother you about final acceptance date, because if that box is checked, that means the final acceptance date is going to be on this document and not on the purchase agreement itself. So that was really good. Now we're going to go to, oh, any questions on that? Anybody have any questions on that? Okay, I think we're going to then scoot on to representation documents. I'm telling you, this thing goes fast. So think up if you have other questions for me, we'll be able to have time to answer those. Again, all these documents you see me scrolling through, there's really nothing changing except for what I've already talked about with data purchase agreements. So that's why I'm not stopping on them. We are going to go to the first representation document they actually had in the packet, and it doesn't really matter which one we do, but it happens to be the buyer rep, so that's the one we're going to talk about. But this change was made on all representation documents, whether it was facilitator or buyer rep or anything. So we are going to talk about line 3. This was a great change. What they attempted to do was clarify who you put on this line when you're putting down who your buyer is. So if your buyer, if the people that are hiring you to buy a property happens to be buying it through a trust, then the trust is your client. So that is the name you would put under buyer, is the name of the trust. If it's an estate that's buying a property, you're going to put the name of the estate. If it's a corporation, you're going to put the name of the corporation. So it helps. And if it's individuals, obviously you put the name of the individuals. So they're trying to clarify what you put in that line 3 would be the clients that are hiring you. Now, remember, when you get to the signature lines at the end, the people sign their names. You don't sign the corporation name, you sign your own name, and then you could put president or whatever your role is after that. But when you're actually signing or who you're representing, you're going to put the name of whatever entity is hiring you, whether it's individuals, an estate, a trust, a corporation. So I thought that was helpful because I get that question a lot, you know, who goes in line 3? Is it just the people or is it the estate, and et cetera? And the same thing when you're listing a property. The client is the estate, it's the trust, but they obviously sign their own name. When people sign for something, they sign their own name and then put their title. So that was all that was done under representation documents there. I thought that was pretty good. The only other thing, any questions on that? Sometimes that one can be confusing to people. Okay. The only other thing that they did on the representation documents is on line 124, you'll see they added text messages. It had never been added as consent for communication. So if you know you're communicating through text, which most people do, then you would have to, you wouldn't have a problem with communicating by text message. Okay, so that's all I have for that one. I'm gonna go to the exclusive right to sell now, because we are gonna talk about that one for a second. Stop me with questions, please. We're gonna, let's see.
So have all these already been updated on Mars? Like, so whenever you go in to the website, it's already up and ready to go then?
There. Yep.
Okay.
Like that since August 1st, or maybe a few days after, for some of your internal documents that had your logo and things put on them, but otherwise
Okay.
everything has been updated already. And you know, you may have had offers and things already and not even realized the changes, because some of them are so minor that, you know, you just don't realize it. So, okay, so we are gonna go to the exclusive right to sell. And the only thing I wanted to show you on that, let's see, I suppose I didn't even have to go to that one. We'll just skip it, but I'll tell you. Under exclusive right to sell now, they have added marital status. So now when you list a property, you're going to put whether they're husband and wife or single, where it used to be on the purchase agreement. And when we go over the purchase agreement, you're going to notice they took off marital status. So there is no more marital status on the purchase agreement, but there is a question on your listing contract. So you can find out if, you know, you have the right people signing it. And then I'm assuming the reason they did that is that the title companies are going to determine who they need to make sure sign the deed and everything. So not up to us to have to worry about that on the purchase agreement, apparently. So that was the only change I had on the exclusive right to sell, and they have that way down on this list of documents. So I'm going to skip that, and we are going to talk about the disclosure statement now. The disclosure statement had a couple of things that I think you will notice that are different than before, and I thought they did a pretty good job. They're, you know, every year they kind of try and figure out what are agents having the most issues with. So here it is. This is the disclosure statement, and on the property disclosure statement, they just had a couple of changes. The first one, fairly minor, but I thought it was good. They're under lines 25 through 28, they have their instructions to the buyer, and they try to do a good job of explaining what it means when a seller says no to any of the questions listed below, that it doesn't necessarily mean that it does not exist on the property, did not occur, or does not apply. No may mean that the seller is just unaware of something. So they're just trying to explain a little bit more on what may be in a seller's mind when a buyer is reading the property disclosure. So that was one of the changes. And then the other thing that they changed, you will notice, let's go to lines 142 through 145, the NA, yes and no boxes. So you check NA if the item is not physically located on the property. You check yes if it's working, and check no if it's not working. So we don't have crossing out lines anymore if something isn't there, and all the confusion that was associated with a property disclosure. Now it should be very clear that if it's not there, you put NA. So I thought that was a good change. Hopefully that helps with some of the confusion. That's really the only changes on the property disclosure worth noting. One thing on the vacant land property disclosure, they did take out some language, and they didn't specify exactly what that was, but there was some language that was taken out that they had brought over from the regular property disclosure that didn't really make sense because there's no structure. So they cleaned it up a lot, they said. So the vacant land disclosure should be cleaned up a lot, and we should notice that if we are using it. I know we don't use it as often, but when you do, it should be a little bit more appropriate for something without structures.
What do you suggest when in filling out that type of disclosure? If the seller doesn't know the answer, just put a question mark, because I know a lot of times they want every blank, filled in. So what would you mark?
Well, it depends on which one. So let's say, they're asking about if it's in an agricultural zone or something. Then I would, put I'm not aware, or I don't know, or, I agree. I don't like a lot of blank lines because you can have a problem with somebody filling in something on a blank line. So we like to cross them off as much as possible, but the seller needs to make sure that they are not answering something that they don't know. So be honest, and if you don't know, right, I don't know. And it doesn't have to be pretty. It doesn't have to look, a lot of them have blank lines after them and things, spots where you could explain or write things in. And they also put, at the beginning when they have that explaining to the buyer what no means, no may mean that they're just not aware. The seller may just not know. And so then they put no, they don't think they have it. And that's up to the seller to decide how they want to do that. But you never want them to guess or lie or anything like that. So yeah, good question. We are going to go to the purchase agreement now. If there's no other questions on the disclosure, we are going to talk about the purchase agreement, which has a handful of changes that were substantive enough that we'll discuss. Nothing crazy, but that is what we're going to go to, and that is a couple of documents down. I apologize if I'm making you dizzy. Okay, we're going to go to line 80.
Hello.
Oh, we have another one. Hello. Okay. We are going to talk about 87. Where are we? Oh, here, this was the listing contract, and you'll see marital status under lines 252 and 261, just to point to, so you guys can see that they did add marital status on the listing contract. We didn't used to have that, so that's a new one. Okay, here's the purchase agreement. So there were a few things of note that I wanted to draw your attention to. They did have, oh, is somebody not muted? I would mute you, but I'm not the host and I don't know how, I can't mute people. So if you're not, if you're talking, you might want to mute yourself. Okay.
Hey, Michelle,
Yes.
really quickly, just jumping back to that, so they took marital status out of the purchase agreement.
Correct.
Why did they add it to the listing agreement?
That's a good question. Well, the listing agreement is really where it matters the most to a realtor, because you need to know if they are married, then in the state of Minnesota, their spouse has a right to that property, right? So in other states, if you're in Wisconsin or some other state where it's different community property laws, then they may not. But in Minnesota, if it's a husband and wife, even if the husband bought the property before they were married, and now they're married, that wife has to still sign things. So that's really where we need to know about it, is when we list the property. So they added it to jog somebody, you know, to ask the question. So if you are sitting down with a seller and it's just an individual, and then they put down that they're married, the realtor is then going to ask, oh, wait a minute, it says you're married, we need your spouse, you know, when can I meet with your wife? Because we need to have her sign as well. And they took it off the purchase agreement, which I get. I'm not sure I completely agree. I think that, you know, that might have us running into some problems with title companies and things, because realtors do such a good job of making sure everything's in order before it gets to the closing. And so if you're not able to double check those things, because maybe you're the buyer's agent and you now don't know if the seller was married or not, there could be some delays, but hopefully not. But they did take it off the purchase agreement, and you'll see that at the end of here. But that's why it's on the listing contract, because it's actually more important for us as listing agents to know whether they're married or not when we're listing the property.
Michelle, I had a question.
Sure.
It's Betty. Yeah, they could be married. Let's say one of the spouse is not around. Let's say if they're from a different country and they're not around.
Mm-hmm.
How do we go about that? Like,
Well,
maybe still waiting for the bride or the groom to come. So.
Well, you know, they're going to have to sign when it comes to closing. You're not going to be able to transfer title without both signatures.
Okay.
It just won't happen. So we like for both, whoever's going to be signing on the title should also be signing on on the purchase agreement, because otherwise you open yourself up for lawsuits and things, or making something not maybe be as airtight as it should be if you don't have everybody in title signing it. So you do need that. Have I seen where one signs it and then you have to wait for the other signature at some point? Yes, I've seen that. But just so they know, and you know, that you are going to need both signatures. That's just the law in Minnesota. They both have a right to that property, so they both have to sign. I don't have a good answer. They're going to have to sign at some point. So, okay, let's see. We are going to look at the purchase agreement. And the first thing I want to draw your attention to is line 18. So what they tried to do at MAR is they tried to clarify some of the things we run into a lot. So what are fixtures? What are things that have to be left at the property unless specifically excluded, which you can always do that in writing or take it out before you list it, really. But one thing that they added was the in-ground pet containment system. So the invisible fence. I don't know how many times I've had to help agents with some issues related to the invisible fence, whether it's people wanting to pull up the wires or are they allowed to take the collars or not. Well, now it is specifically put in that the wire system, the in-ground system, is considered included. It's underground, it is considered included, and that also, from what it looks like to me, includes the panel in the garage. So if any of you have seen it, there's usually a panel in the garage, and then there's the underground system. And then the only thing that's not included, because it specifically states it here, is the actual collar that the dog is wearing. That is not included. So you can take the collar with you. And I guess from my understanding is that those collars can be recalibrated to a new system. You know, if you have a new system at your next house, and you don't have to buy another collar because you're taking it with you. So that has been clarified that the in-ground system is included, excluding the collar itself. The other thing clarified are ceiling speaker mounts. We get that question a lot too. Are the speakers included when they're attached? And they specified that the ceiling speaker mounts are included. I guess that's the part that's actually attached to the ceiling, is the mount itself. That is included. The other thing that they talk about is lines 24 through 26 are the integrated phone and home automation systems. This is like your Nest doorbell or your thermostat, you know, that are people can control from their phones, those kind of thermostats that are in-home automation systems. What they're saying is all of that hardware and those devices, the doorbell, the thermostat, those are included. The only thing that's not included is your actual mobile device, meaning your cell phone. So you may use your cell phone to control your thermostat or control and see your Nest, you know, doorbell, but you don't have to give somebody your cell phone. You get to keep your cell phone, but the other components, meaning the doorbell or the thermostat itself, those are included. And you also have to give whatever passwords or codes or permissions that you would need to give them so they can then use those doorbells and thermostats. You have to make sure that you are giving that or giving them access to that information. Often people will disable it so then people can use it themselves and start their own passwords and that sort of thing. But you have to disable it so then they are able to get in, or give them your passwords if that's how you want to do it. But either way, they have to have access, and however you need to do that is important. Any questions on that? So hopefully we don't have as many fights about Nest doorbells, because I see a lot of them. The next thing we're going to talk about is they,
I didn't realize I was muted. Is there anything that indicates that the seller, you know, they still control it? Or is there anything that indicates they have to remove all control of those remote devices?
Well, it says that you have to give them the permission to do it. So I think, and you have to give them the access information. So if it was me arguing this in a court of law, I would state that if they then have the access, you no longer should have the access. So yes, you cannot have the access anymore. When you give them access to use it, you take away your access.
So we should be telling sellers they need to remove any access codes that they have. It doesn't say that particularly, but I think it should be done.
I agree with you 100%.
Okay. Thank you.
Yep. Okay. The other area they changed a little bit is the financing on line 60. They just combined conventional or privately insured conventional are on the same line. They used to be on separate lines apparently. So those are on the same line there. What else? They added, oh, here, let's go. The rest of that isn't much. Added language to the VA funding section, clarifying, let's see, the amount that the funding fee is based on. So lines 143 and 144, they talk about VA funding fee, and that one-time funding fee that people have to pay is based on the loan amount. So sometimes we get the question of how much is the funding fee going to be? Well, it may be different depending on what the loan amount is. So they just added the 4 words based on loan amount so people know what that funding fee is based upon. That was the only thing they did, is they added some language there. Let's see. They added some other language clarifying that, let's go. You're gonna see some yellow stuff, but the words executed as opposed to written were added to the document. So you're gonna see in your documents, instead of when a document says previously written purchase agreement, they took that out and now it's a previously executed purchase agreement. So let's say you checked a box that said this purchase agreement is contingent on a previously written purchase agreement. That didn't make sense, because if it was never delivered, then it shouldn't have mattered whether you had written a previous purchase agreement. It wouldn't be contingent. It'd only be contingent on a previously executed purchase agreement, meaning it was written, it was delivered, so it was in full force. So you're going to see that in a couple of spaces, and I think, let me see where they clarify that here. Here it is. Lines 444 and 445, fully executed purchase agreement and final acceptance. It explains, to be binding, this purchase agreement and all addenda must be fully executed by both parties and a copy must be delivered. That's what it means to be fully executed. It is that it has been signed by both parties, executed by both parties, and a copy must be delivered. We all know that as agents, but now it is spelled out much more clearly in the purchase agreement so buyers and sellers can understand that. I thought that was a good addition. And again, you'll see the term executed in a couple of spots where it used to say written. The other thing they did was they modified the date of reference for risk of loss, and I'm going to show you that. Line 321, here it is. If there is any loss or damage to the property between the date of this purchase agreement, which remember, now when we say date of purchase agreement, we look right up to that number at the top. We don't look at the final acceptance date, we look at this date. So it says, if there is any loss or damage to the property between the date of this purchase agreement and the date of closing, for any reason, et cetera, et cetera, et cetera, this purchase agreement is canceled. Everybody agrees to sign a cancellation confirming said, that sort of thing. So the risk of loss has been there, but they did clarify that that loss is between the date of the purchase agreement and the date of closing. So hopefully that helps with any issues on what date we are talking about there. So that was pretty good, I thought. Let's see, any questions on that? I know that can be confusing. We went into risk loss issues. They did, like I stated, deleted marital status. So that's lines 505 and 506. At the end, you will see that. So there's no more marital status down there. There used to be. And here, I'm going to draw your attention to line 494 is where they talk about that final acceptance date is now noted on the counter offer. So if you check this box at 491 that there is a counter offer attached, you don't have to put your final acceptance date down here on line 506 anymore, because it's going to go on your counter offer addendum. So I'm not going to look for it there anymore. So I thought that was a good little clarification.
So then wouldn't have it made sense just to make that obsolete, not even put 506 there anymore then, if that was the case?
Well, no, because oftentimes you have no counter offer. So if there is no counter offer, then I'm still going to look for.
Okay, so if there's a counter, then you have the addendum. If not, then you're going to put it there.
Correct. And that's why it's so important that people are crossing things off and doing their counters actually on the purchase agreement, because that can be confusing. It should be done on the separate addendum, which I think people have gotten used to. It took a few years, but I think people have gotten used to using that counter offer addendum. And so, yeah, this way we can all see there's a little box checked. We know that there's a counter offer attached, and that's where we'll see the final acceptance date. The other thing I wanted to bring your attention to is these boxes from lines 472 to 484. There was a lot of talk about the COVID addendum being added, and they decided not to add a checkbox for it because they're hoping it won't be here forever. So you will not see a COVID addendum. Doesn't mean that you shouldn't be using it. If it, you should be using that, and you can always write in on a blank line that there is an attached addendum if you want to draw attention to that. But there is not a box that's actually there for you to check. There was a lot of discussion about that at MAR, and that's what they decided to do. That is all I have on the purchase agreement. The only other little thing I'm going to draw your attention to, just because I get so many questions on it, is this little box at the end, 510 through 514, that talks about the arbitration disclosure. They tried to help clarify that the arbitration disclosure or the arbitration agreement is a separate document that is separate from the purchase agreement, and that all it means to sign these boxes here is that you are acknowledging that you were given the opportunity to look at that arbitration agreement. And so you have been given the knowledge on what arbitration is. When they sign this, they are not signing if they want to have arbitration. They are just signing that, yes, their agents presented them with those documents about arbitration. So they're trying the best they can, because I don't know how many times I have agents say, my clients won't sign up, they don't want to do arbitration. I say, well, that's because we're not doing a good job explaining to them what this is. This is not stated.
Michelle, could you please explain to me, like, how to explain arbitration?
I wish I could. I will do my best, but I'm going to tell you from the beginning is what I have recommended for everybody is that at your consultation is when you present it to them, and you should be giving them that entire packet that MAR put out about arbitration. It's thick, and they do such a good job going through what arbitration is, the cost of it. I mean, we didn't used to have any of that information, and now it's all in that packet. So when you're doing your consultation, that is when I would bring it up and say, you're going to have the opportunity to decide if you want to go through arbitration if there's a dispute after the transaction closes, and if your dispute is more than $15,000. So what you have to remember now is that arbitration only kicks in if it is above the dollar amount of $15,000. Otherwise, all disputes, if not settled informally, are settled in conciliation court. And conciliation court only goes up to $15,000. And then after that $15,000 mark, if you all sign arbitration, then anything above that, you would settle in arbitration. If you don't want to sign arbitration, and if one of the parties doesn't sign it or none of the parties sign it, then you would go to district court, regular court, for anything over the $15,000. So that is to the extent of kind of explaining what it means if you sign it and if you don't. As for if it's better to sign it or not, we never give our opinion. That is not something you want to do because you don't want to be responsible. Decide so that you say.
If you don't give your opinion, how would you say that? Ask legal advice?
Yeah, you say, I can't give you legal advice. It is up to you on whether this, you know, what direction you want to do. Here are all of the documents we've been given, and they explain the benefits of arbitration and the downfalls of arbitration. You know, it could be, I think the documents talk about how it could take less time and you go through arbitration than district court, but it could, but you're not in front of a judge. And, you know, so there's a lot of different things. People ask me all the time, which one would you do, Michelle? And I honestly don't have an answer for them because I've done both. And in different circumstances, I've been so glad we did arbitration. And in other circumstances, I am so happy we went to court. And I wouldn't have known that until we actually found out what the dispute was about. So you don't know ahead of time which way is going to work out the best for you. And both are great alternatives. We can't decide for them. We can't give them those recommendations. All we can do is present them with what MAR has provided and explain to them that if they have questions or they're just not sure, they should talk to an attorney because they might be able to give them some legal advice on what they would recommend.
Is that information from MAR available with all the rest of the documents? I don't remember seeing it.
Oh, really? Your market center, I'm sure.
Online.
Yes, Katie, yeah, has it. It's a pretty thick packet that MAR provided, and we don't ask you to upload that to Command or anything like that. All I want is the actual arbitration agreement, but it is provided from MAR. It is online. Talk to Katie because she'll tell you exactly where that is. And I think it is so important that at your consultation, before a client is given that arbitration agreement and has to make a decision at the time of purchase agreement, it's too late at that point. They needed to learn about it beforehand so they know when they get to the point they're writing up or accepting a purchase agreement, which way they want to go. And so at your listing consultation or at your buyer consultation, that's when you give them that packet and say,
Michelle,
you know,
can I
want you to
jump in
review
really
this.
quick and explain where that is?
Sure.
That arbitration information is right in Instanet in Transaction Desk in North Star. It's just titled arbitration information. It's just like another form.
Really?
Yes. Yep, you can access it there.
Okay.
Michelle, I have a question in regards to the arbitration. What if the buyer signs it saying we want arbitration and the seller says no?
Right. So you have to explain to your buyer that arbitration is only available if all parties in the transaction agree to it. So you may not have a choice. If one of the parties doesn't want it, then it's not available. There's nothing you can do. It is only available if all parties agree to it. And so you just have to do a good job of explaining that to your buyer, that I understand you want this. We can't force people to go through alternative dispute type resolutions. Court is always available to every American, but arbitration is something voluntary and we can't force them.
But if they sign arbitration, they don't have the right to go to court.
After $15,000, correct. If you sign arbitration, then you are saying that if it's more than $15,000, we are agreeing to go through the arbitration process instead of a district court, correct. And the same thing, if you don't sign arbitration, then you can't utilize the arbitration system. You are then going the court system. So it's, you know, that's their, and that's a decision that each party has to make. We have always said, and most of the market centers I've worked with have said that if our client wants arbitration, we are not going to stand in their way. So we sign arbitration. Because remember, it's all parties in the transaction. That means both agents have to sign it as well as the buyer and the seller in order for arbitration to be a viable option. So that is why we generally have our agents sign it, because we don't want to be the impetus. We don't want to be the reason why our client can't utilize arbitration if they really want to. So that's why we have always signed it. Any other
So
questions?
Michelle, I sign it no matter if my clients do or not. And then I've had some agents not sign it. Is
Well,
that?
we can't force other brokerages. Other brokerages have their own policies, and we have no control over what a different brokerage does. All we can do is have policies. Your broker can set policies in your market center, and that's it. If another brokerage has decided, we just don't sign that. We don't care if our clients want it or not. That is a policy that we have, and we don't sign it. Then you have to explain to your client that, I'm sorry, everybody in the transaction has to sign it. One of the parties has chosen not to. So if for some terrible, instance, we have to go through some sort of dispute resolution, you're going to have to do it in a more formal setting in a courtroom, because not everybody signed it. So
Now, question. I know you saying that not all parties have to sign, but say your party signs it, your buyer, you sign
all
it,
parties have to sign it.
but then you send it to the seller to sign, and the seller says their client decides to decline.
Right.
But on the form, it doesn't say anywhere where they decide to decline. So then how do you, I ended up having to keep an email where they actually declined the arbitration. So on the form, is there anywhere where there is a part that maybe I missed or something that the agent, the seller declines or anything like that? That way I don't have to add an email to that.
Right. So we have always told our agents that if your client doesn't want to sign it, the best thing to do is to have them write decline, because then there's zero confusion on whether they just didn't see it or whether they actually don't want to do it. Other brokerages may not have that same policy, and they may.
And that's not to mention, that's really hard to do when it's electronic signature.
Yeah.
Yes, it's not.
They don't have the option to write on anything.
Right.
Exactly.
I get it. Yeah, it's not as easy as it used to be, where
No.
we just write decline on it. So other brokerages may say, if they don't want to sign it, that means they've declined, because you have to sign it in order for it to be effective. And they just have said they're not going to sign it, and that's it. We cannot control what our brokerage does. We don't. Now, there's nothing wrong with doing what you did, sending a quick email and saying, I noticed that they didn't sign it. Is that their intention, or did they just miss it? Or are they gonna, did they decline and you want to write decline? There's nothing wrong with you drawing attention to it to make sure you understand that it wasn't just a missed document and maybe that one didn't.
Oh, no, they just made it very clear, my client declines, but they weren't able to write anything on the document because it was through AuthentiSign. So I just saved the email.
That I think is perfect, regardless of whether they write decline on it or they just don't sign it. If it gets disputed on whether or not we can go to arbitration, they're going to want to see a document that has all the signatures. And if one of the signatures is missing, they're not going to allow it to go through arbitration. So the only reason that we try and clarify it, if possible, is because we have been in lawsuits. We have been in situations where people have disputed and said, I wanted arbitration and you just never showed it to me. And they say, yes, I did. You just chose not to sign it. And there we have nothing to back up, no emails, nothing to show that, yes, we did present it and you just chose not to sign it. And so it's easier if you can just prevent all those issues by formalizing it and seeing it in writing, whether they want it or not. But nothing is perfect. We do our best to try and button up as many things as we can, but there are going to be instances where it's just not going to be perfect.
I have a quick question for you, Michelle, for clarification. You had said that if all parties do not sign the arbitration disclosure, nobody can change their mind. They are not allowed to go to arbitration later?
Well, if they choose, it has to be signed at the time of the transaction, or you don't have an option. However, could you go back and later on and get everybody to agree to try mediation or arbitration or something like that? Absolutely, but there is nothing, but it would have to be re-signed. Meaning, let's say 3 out of the 4 signed it originally and only one party didn't. That one party who didn't sign it can't then go back a year later and sign it, and now everybody's bound by arbitration. No, everybody, even those that had signed it originally, would have to re-sign because
But it is still an option then.
Possibly.
I mean, let's say that the one party doesn't sign it, and then they start looking into it and they're like, well, gee, I think maybe I'd rather go.
But what you have to understand is that and I've seen this happen numerous times, is that the people who signed it at the beginning, then it comes back around and they say, oh, we did want arbitration. We would like to do that. And the people who signed it at the beginning say, forget it. I'm not signing that. You take me to court. It's going to cost you a whole lot more money to try and sue me and hire lawyers than it is if we go through arbitration. So they say, no, I refuse to go through arbitration. So as long as we do a good job in educating our clients, the problem we run into is when we tell a client, you don't have to sign it because you always have the option later. Absolutely not. That is a lie. That is legal advice, and that is wrong. You may not have that option later because people in the transaction may not agree to it at that point, and it is only effective if everybody agreed at the time of the transaction. Is it a possibility that everybody will think about it again and sign it, decide to go through arbitration? It's a possibility. Anything's a possibility, but there is no guarantee that the people who originally wanted it will then a year later agree to it again because they're not bound by it. They were only bound if everybody signed it at the time of the transaction. So is it a possibility? Sure, there's possibilities that, anything can happen. But I have seen it time and time again where people don't do a good job of explaining to their clients that if you don't sign it now, oh, don't worry, we can always decide to do it later. That may not be the case. So don't give that advice. You got to be very, very careful. If you want arbitration, sign it at the time of the transaction because later on, maybe people will agree to it and maybe they won't, Does that make sense? Okay. All right. So that is the last thing on the purchase agreement. The only other thing I wanted to draw your attention to was on the lease agreement. I'm seeing it a little more now that people are helping people, renters lease properties, and they're using the Mars residential lease agreement. So they did make one change on the residential lease agreement that I thought was notable. All they did was they added an option. Here we go. When you're helping your clients decide on how they're going to pay rent, they added an option. Here we are, line 124, lines 17 through 20. So the terms of the lease were changed a little bit where they added the month-to-month option. So instead of only having a yearly lease option, which is line 16, they then added a month-to-month option if that's what the tenant and the landlord have decided on. So that was good if the two parties have decided they want to do month to month as opposed to a year long or 6 month long or whatever lease. So that was the only change on there. That is all I have. I mean, there really wasn't that many. So if you have any questions on anything else, please let me know because this is the fastest I've ever done these. Usually it takes me hours, right? And I always go over and, but not this time. So I am gonna get rid of my screen, maybe. I told you I don't know how to do any of this, but I'm gonna try. Okay. Oh, here, you are screen sharing. Oh, we had chats. Sorry. Thank you. Oh, I think I answered all the chats that were on there. Choose arbitration later, and Trudy answered that. So I think we're good. Anybody have any other questions before we sign off? Oh, there you are.
There you go. Thank you.
Yeah, absolutely. It was so good to see you. Thank you. It's beautiful. Look at Karen. I'm very jealous.
You can be in New York or in San Francisco or at a pool. So it's kind of fun to change the background.
I love it. I'm going to try that next time.
Have a good day. Thank you for
Have a
your
good one,
questions.
Michelle. Thanks, everybody.
Thank you. Bye-bye.
Bye.
I have a quick question.
Yes.
Can you hear me?
Yes, I can.
I noticed that you had those all those forms highlighted. Is that saved someplace where we can kind of go back and print them out to go, oh yeah, here's exactly where it was changed?
Yeah, absolutely. Mar put those out, and so I think I tried to send them to all of the MCAs, so I will check with Katie, but I'm pretty sure I sent them to her, otherwise she has access, but all of you have access to these highlighted forms because it's on your the Mars agent portal of their website. You know, as long as you are a member of MAR, which all of you are, you have access to this. But I'll just make sure I email it to Katie one more time if I haven't already, so that she can just send it out. So yeah, I will make sure you all have that, because I agree. There's so many, there's so much text to look through, and it's so nice that it's highlighted and you can just see that where the actual changes are, because most of it stayed the same. So I'll make sure you have that.
Thank you.
Thank you, Michelle.
Thanks, Michelle.
Okay, bye.
Bye, everybody.